What's going on, guys? Vinark MP here. After doing a quick survey, I found that most of you want more information on the laws and regulations and rules of family court. I was able to research and find this amazing family court crash course specifically for fathers. Now, this comes from Canada, so like I say in every single video, you gotta take the information with a grain of salt because every single state, county, township, and sometimes city have varying degrees of differences inside of family court. What I do know is that in North America, meaning Canada also, and even England, family court is very similar. So this is a great place to start laying groundwork for a better understanding of how a judge thinks, what due process looks like inside of family court. As you know, I'm not a lawyer. I can't be your lawyer, but this is a great place to get some good information so you're not walking into family court blind. Grab some popcorn, grab some Gatorade, sit back, and enjoy this great informative session. Shout out to all of our brothers in Canada.
So welcome to our legal clinic, family law legal clinic. First time you've done this. My name is David Shackleton. I'm the president of the Ottawa branch of Canadian Association for Equality. We put on regular events about once a month on some theme associated with men's issues or gender equality. So this event is a legal clinic. Is there anybody here who's concerned about appearing online in a film of this event? We'd like to put the information here up, and if you don't want to appear on the film, we'll make sure that doesn't happen in the Q&A period. Nobody? Great, makes it easy. Okay, so as I said, we do monthly events. Our next event is going to be on February the 22nd at the University of Ottawa. It's called She for He. What it'll be is a panel of 4 women talking about the legitimacy of men's issues. So this is kind of a morale builder for guys that some women get it. That there are legitimate men's issues that are as real as the issues that women have brought to our attention and we have rushed to fix for 50 years now. We're also trying to open a center for men and families. So CAFE has such a center in Toronto. It's been open for 2 years. It's full-time, it's staffed, it has services for men, support groups, clinical services, educational events, and so on. We want to do that here in Ottawa. So we're in the middle of a fundraising drive. If you have the ability to contribute towards that, your contribution will be matched. We have a $25,000 matching donation from a Toronto supporter. So up to $25,000, every donation will be matched, so doubled. You will also get a charitable receipt because CAFE is a registered charity. What else? That's all. So let me introduce our speaker. So Jean-Jacques is from Sudbury. Your name is DeGrange, right? DeGrange, right? Jean-Jacques DeGrange is from Sudbury and has been in Ottawa since 1992. He was admitted to the Ontario Bar as a lawyer in 1997. He's a public servant, but he also practices law part-time in a number of fields, including family law. His interest in family law began when he was refused custody of his daughter. His daughter is now 27, and he enjoys a great relationship with her. He has since then been keenly aware of injustices to fathers in family courts and is trying to change this one small step at a time. So at this point in time, he's very involved in a parental alienation case. And he trusts that it will be successful so that it might be added as case law in support of other similar alienation situations. So please welcome Jean-Jacques.
So hi everyone, and I'd like to thank Cafe for giving me this opportunity. I'm also very happy that I can provide some knowledge here to those who might be in dire need of it. So family law, I'm not going to do or repeat what David said, but I've been working in law for a long time, and I've been giving a lot of advice, free advice on the side. It's only lately that I've started to take on a bigger role as in going to court, and when that's up to family law. I did small claims court and stuff like that before, but now I'm just taking it on more. And so when I was approached to give a legal clinic, it couldn't be better. Okay, it's right exactly where I want to go. I want to help people out, especially those who have trouble with not seeing their children. Really, that's where it's at. So the presentation I'm going to give today, you have a paper copy, and a good copy for okay. So what I'm doing here is presenting an introduction to the system. I can give you a lecture on the law, how everything, and God knows you probably looked it up on the internet, you probably did some reading and stuff. What it comes down to it, what I found out in doing my work is that most people get lost in the technicalities, and in particular with the procedures. So it's all nice to know that we have rights, but how do you enforce that? That's the difficulty. So you have to be able to prepare some documents, you have to be able to show yourself up at court, and even just to get in front of the judge, there's a whole bunch of things that must be done before you can even get there. So I think so I thought it was good to give you like a workshop on the practical side of things, okay? But before that, we're still going to cover a few basics with regards to the law, okay? So if you look at your the presentation I got here, we'll start with an outline, which we'll have the forward. We'll talk about legislation in Ontario. We'll talk about maybe the most important thing, which is your story and the evidence. And then we'll look at the regulations, okay? How do we go about building a case, bringing the stuff to the courthouse so we can go to the next step, okay? So, as a forward, family courts is just like any other court system. The reason you go to court is because you don't get along with someone on the point, and you're going to have somebody decide for you because you two can't get along. That's what a judge does in most instances of civil litigation. There's other rules for judges. I'm not going to talk about that today. So that's what that forum is all about, okay? And when people don't agree on things, and they throw themselves in the third party in front of the judge is going to apply what's called the law. The judge is going to look at the laws that were passed by government, okay? He's going to look at what was said before, as in case law. Okay, we're going to apply the same tests again, and you're going to have to live by my decision, because that's the way I figure the law should be applied, okay? Now, there's good reasons for that, okay? If a judge was able to decide anything anyhow, nobody would know what would be coming at them at any time. That's not good. You need some kind of stability. So that's a good part of it. Unfortunately, a lot of the times, there's not enough movement within the court system to make the law change, okay? The law changes by case law. We'll get into that a little later. So I spoke about the application of the law. The application of the law, just to sort of repeat myself, is a matter of taking facts. You're taking facts, things that happen, okay, and you're applying these legal principles to it to determine what's legal and what's not. And this is basically the exercise that a judge is doing. Now, your job when you go to court is to convince the judge that the law applies this way in your case as opposed to another person's case. Or if there's a similar situation, you're going to tell the judge, That's what they did in that case. That's what I want you to do here. But your job when you go in front of a judge is to convince them. Now, I understand that some people are a little scared of showing up in front of a judge, but basically a judge needs to hear that. True, he's up there on the pedestal, and he's got the nice little band across, and it can be somewhat intimidating. But there are humans too, okay? And their job is to listen and to come up with a decision. It's just the way you're going to present that makes a difference, okay? Now, lawyers are trained in that, that's good. But a lot of people can't pay for lawyers. So you have to take that on to yourself to do, okay? And yes, you can do it, okay? All right. Next step is we're going to talk about the legislation. Now, there's a, if you look at slide number 4, there on the other side of the page. In order to be able to sort of come up with different, to stabilize, if you want, what people can expect, the government passed laws. So I don't know if this is going to come as a surprise to you, but before we had a law on Children's Law Reform Act, by and large, it was common law, which means that it wasn't nothing written in paper. It was just the decisions that said that, okay, well, the kids are going to stay with the father, okay? But that didn't suit certain people at one time. So in order to change the common law, which was case law, as opposed to law that's passed by Parliament and stuff like that, they decided, in order to change that, they passed an act. And that act is called the Children's Reform Act. But there's other acts as well. You have the Divorce Act. The Divorce Act, I don't want to get too complicated here, but the Divorce Act deals with divorce as well as taking care of child support, child custody, and all those aspects, okay? And divorce is a federal thing, which is why you have the Divorce Act. But for those who aren't married but have kids, you don't fall under the Divorce Act because you're not married, right? So, to come up with the same plan, the Ontario government came up with what's called the Family Law Act, okay? And it's basically the same thing as the Divorce Act. And you have a number of things in there, including the Family Law Act. We'll talk about, let's see here, let me think. I think it talks about child support. Yes. Child support, child custody, and division of family, or division of assets between two people who who are not married, okay? Basically the same thing as the Divorce Act. But that's where you get your rights as a parent, okay? Likewise, you also have another one called the Children's Law Reform Act, and it has nothing to do with reforming children. It has everything to do with reforming the law that was back then, okay? So the Children's Law Reform Act there will deal with how to determine if a child is yours or not. It'll deal with adoption. It'll do everything that surrounds children, okay? And that's where you'll find provisions that will speak to the best interest of the child. Okay, which is the primordial rule in everything. When you go to court and there's children, it's always the best interest of the child that counts. It also deals with parental rights. Who gets custody? Who gets visitation rights? And we won't go into that. The Children's Aid Society, the whole slew about the Children's Aid Society is in there as well. Okay, and that along with another law, another act that was passed, but a lot of it is right from there. So that's the legislation part of it. So you can go through that section by section, examine what applies to you, what you want to do. We're not going to do that here, okay? We're going to deal with very small parts of those actions. And we'll get into that in a few minutes. But I want to go now to the next slide, which speaks about your story and evidence. Because you can have acts, you can have laws that are passed and everything, but if you can't present a good story, you're not going to get what you want. And when you present a good story, you have to have evidence. Okay? And this is key if you're going to get anything done in court. Okay? So, it's your story when you go to court in family law. It's your story versus the story of the other person. And you can get very emotional about this because most of the time, those stories, especially when you're in front of the court, they don't agree, okay? They're different, okay? So the story you're going to give has to be truthful. Now, there's always two truths. And then someone says there's always the truth, your truth, and there's somewhere in the middle is probably the actual truth. We don't know, okay? But your story has to be truthful. You got to be able to provide your story based on verifiable facts. Okay? So in other words, she hit me. Okay? Maybe she did. Can we verify that? Well, yeah, look, I got the proofs. You know, or something like that. Now that's a verifiable fact. That's something that you can actually go and get and include. Okay? So if you're going through a family law case, or if you have, or if you're about to, okay, my suggestion to you is get your facts straight. Make sure you have them clean, okay? Keep your evidence. Evidence includes emails and texts. Okay? Telephone call recordings. Okay? Some people say you shouldn't do that. I tell people to do that. Now, whether they'll accept it in court is something else. But at least you have it there, right? If you need it, yes.
But don't you have to ask permission or let someone know?
As long as one person has knowledge, it's fine.
Well,
One person in the conversation has
Go ahead.
knowledge. You can't bunk a room and have a different private conversation, that you can't tap somebody's house or whatever, but if you're walking in, you have a right to record your own conversation.
your own conversation is not a problem. Taping
Even if the
somebody.
other person doesn't know.
Yep.
Yeah. Okay. Yeah.
Okay.
I know, I drive lots
So,
of ground.
but
for a
again,
reason.
there's rules here. You're absolutely like, yes, whoa, whoa, whoa. In other words, don't say anything anywhere because you can be taped at any time. I say tape it anyway. Video everything. You know, I mean, whatever, okay? You don't have to use it, but at least you have it in hand if ever you need it. And I mean, this becomes really important when, in cases where someone accuses you of mistreating your child. Okay? You've taped certain things. No, look, we've been talking. You can demonstrate a lot of things by these tapes. And that's evidence. It's very important. So, because in the end, it's your word against the other person's. And the only way you can actually trace it back is to come up with this evidence. Okay? So videos. Also, if there's other witnesses, get their names, addresses, phone numbers, okay? And then ask them if they want to testify. But get that first. Okay? Chances are they might not want to, that's fine, but at least you have someone to go to. Now, they're not necessarily going to testify upright, okay, in court, but you can probably get them to testify on paper. Tell a story. We'll talk about affidavits a little later, but get their story, have them swear that it's true. At least you've got something to go on, something that's outside from a third party, especially if it's not connected to you at all, okay, then you've got something that really has a lot of weight when you look at the weight of evidence, right? Okay? So, you have to learn basically to craft your story, to write your story. Okay? These documents, and we'll have a look at a few a little later, okay? These documents rely on the written word. Okay? Eventually, in front of the judge and you talk to them, that's fine. But everything that comes before that is the written word. So you have to, if you don't know how yet, you have to learn to write your story. And the story is written, you don't philosophize in this, okay? You speak about facts. This is what happened, boom, 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 okay? And you don't write you write in paragraphs, but very short ones. And they're numbered. So some of you probably saw that, seen that before, but they're numbered. And they're very short. Reason for that is we don't care about the philosophies and stuff like that. You just want to say, this is what happened. Boom, 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 okay? And besides, think about this. A judge, family court especially, he goes through how many cases a day? Which means he probably had to read most of those files. He's tired. He doesn't need to have all kinds of things thrown at him. Very nice, clean, this is what happened, this is what I want, okay? All right. So, before I move on, if there's any, we can probably look at if there's any questions with regards to that, with regards to that whole aspect of legislation, getting your story right. Is there any questions on that? Yes.
I'm just wondering if this divorce act, would it also apply if you're common law, like you've never actually been married?
No.
That was-
The divorce is, the divorce, okay,
It's only.
That's the Family Law Act.
yeah.
Okay, good.
Yeah. So the reason why you have two acts like that, I'll go into the legalese there very briefly. So when the Fathers of Confederation got together 150 years ago, all right, they decided that divorce, marriage and divorce would be at the federal level. And the feds would take care of that. All right? Well, that leaves a whole bunch of people who never got married out of the picture. Okay, so you've got that act, which is a federal law, okay, which basically does the same thing as the Family Law Act. But Family Law Act is for those who are not married, okay? Now, the main reason for having it federal is so you can keep registers of who's married and divorce registers and all that, because it is a monogamous culture here, right? You have to know if someone's divorced or not before they get remarried. Yes, sir.
Just the family law here is provincial in Ontario, like is there equivalent, I'm sure there's equivalent in Quebec, and like
Yeah.
how do those interact?
Yeah, there's something equivalent. I don't have it in mind right now, but there's something equivalent. There's a major difference between the Quebec and Ontario is that in Quebec, it's an automatic joint custody upon separation. So both have something to say with regards to the kids.
Okay.
Right? In Ontario, it's not that way. It's the best interest of the child that counts. And if it's the best interest of the child, well, there's a number of doctrines that came out, which is, one of them is the tender years doctrine. The other fallacy is that men can't take care of kids. You know, that comes into play. So in the end, most of the time, the kids are sent with the mom. So, but I was talking to someone from Quebec not too long ago, said even though it's joint custody in Quebec, they won't necessarily apply it factually, just like that. A lot of the times, they're all it's best if the kids with mom and but at least they're right off the bat, they start at joint custody, and then you have to argue against that. Whereas in Ontario, you're stuck having to argue that you're just as good as mom to take care of the kid.
Something I've never understood is, and correct me if I'm wrong, but I understand your legal principle here, but rights trump interests in law. In other words, interests are, I mean, it's in my interest to have all of your money, but your property rights trump my interest in yours, right? So rights kind of are higher than interests. And yet, in family law, we have this thing about the best interest of the child.
Yeah.
And it seems to trump rights about, property rights that parents might have and so on. But
Yeah.
How do you understand that?
Well, I think that from the beginning, what they're looking at is the child as being this being who's innocent, who's got really should be put in terrible situations and whatnot, and a very vulnerable person. So it's that the interest we have in the child is to make sure that they're in a safe, okay place.
Why didn't we make that the rights of the child as opposed to the interest? Because interests are
presumably-
essentially unlimited.
Yeah, presumably because, you don't have that many rights until you're 18, right? But there's the children's right, I agree, there's a whole thing about the children's rights. To what extent should we take that? I don't know, okay, but in the end, it was called the best interest of the child. They may have taken that right out of, some university philosophizing about, what's best for the child, simply. And say, okay, well, we're going with that particular theory, and boom, and put it on paper, and there you have it, okay?
Let me just tell you where I'm coming from with that. I think if we talked instead of the interests of the child about the rights of the child, then they could be enumerated and they would be limited. So the rights of the child is basically that the parents would support them to a certain basic level that would be their right. But with interests, what we get is that there is no basic level where it cuts off. Instead, if the father happens to be a millionaire, then the interests rise to, to a much higher level of income. And so I just wonder about that. It looks to me like there might have been a hidden agenda when that was set up. Because, really, what I think would be appropriate would be that the child's rights would be addressed after divorce. But
That's an interesting concept. I've never really thought about that. Maybe they did think about it then, when they drafted the legislation. Maybe it's time for someone to lobby on that. I don't know. But no, point very well taken. I'm sure, I didn't research that, so I can't come up with a very clean answer, okay? But bottom line, yeah, it's the best interest of the child that rules. And well, we'll see as we go through the course or as we go through this course or this workshop and when we go to court, that's applied very freely. So that's probably your answer right there, okay? It's not a right because a right is something that belongs to you, whereas an interest is you can play with it, right? Yeah. Okay. All right. So right now, if there's no other questions, we'll move on to going to court and the procedures. Now, I'm going down to the practical stuff here, okay? So if you guys want to talk about the law and what the law says, I have no problem with that. You can ask questions on that at any time. Like I said, I just think that the practical aspect is probably better. Okay? So going to court requires two things. You've got legislation and regulations, or rules if you want. It's like a game. Okay, a game, you have the board, you have this, you have that, but there are rules you need to follow. So, although it's a very serious game, much more serious than, say, risk, you still have to follow, you have to follow the rules. And the rules, to give you an idea, is all about process. And I gave you a rundown, in a package you have in front of you, you should have, I'll try to find it. Here we go. It's the one that's called Family Law Rules. Okay, it's the third page in. Okay. So family law rules are the rules that tell you how to go about getting your case heard in court. Okay, this is not the law. It's all about how to prepare, okay? So whenever you see interpretation in one of these, it's all about definitions because they can call, they can call an hour, they can define it as, 90 minutes, 1 hour equals 90 minutes. They can do that, okay? You can do that. You can change things all, but the interpretation, it's all about definitions. And a lot of the times you have to go back to find out, okay, what do they mean by that? The time aspect is when you must give documents. So if someone serves you documents, usually you've got 20 days to answer to that document, okay? So if someone says, here, I want custody of the kid, tough means you've got 20 days to answer that. So that's the time, and that's the time calculation. So does 20 days mean with or without weekends?
Without. Without.
Okay.
20 business days, isn't it?
No.
It's not.
No, it's not. If it's less than 10 days, it's 10 business days. But I'm telling you right now, this right now, but if you look in there, you'll have a very good, and the rules change depending on which rules there are, which province you're in, the whole thing, okay? So, but that's where you get the interpretation as the time, okay? All right? Representation, that's who can represent you in court, and where the case starts and where it's to be heard. That's probably an important item. By and large, if the case is to be heard where the child resides. So, if you're living in Ontario and the kids are living in Quebec with mom or dad or grandmother, everything happens in Quebec because that's where the child resides. It can be an issue here, In the one case I'm dealing with right now, mom resides in, well, just outside of Toronto. So I'm stuck going to Toronto pretty often because that's where I have to go to court. Okay? It's the way it is, okay? I have to make a choice somewhere, and that's where it is. Unless, of course, the parties agreed that it's going to happen somewhere else. But if you're already in court over something, chances are the agreement is very far. Okay? So that's where the court, that's where the case starts, versus to be heard. And then there's the service of documents. Okay, service of documents, we serve you a document, you have to answer to that, and the other one gets a reply. That's how everything starts. We'll see that a little later. And if you, and I'm not going to go through the whole thing, but bottom line, if you look at this, it's quite chronological after you go through the technical stuff, okay? Technical stuff like the definitions, representation and stuff. How do you start a case? Okay, how do you, what's the next step? It's all written in these rules, okay? And in fact, I'm not going to go there. These are the family law rules. They make things relatively easy for us because with these forms. And right now, you've got a notice form 14 in your thing. That's just as an example. We'll look at this a little later. This notice of motion form, it's all ready for you. You fill it out. You write whatever you need on it. You use extra pieces of paper. Okay? But that's what they made it really nice and easy for us. The names of the people are in the boxes. They had to do that because before we had to, there was a book on how you went about to write these documents. Okay, but this facilitates everything for everyone, so that's good. And yeah, so as I said, this is chronological. Okay, and so you refer to the rules all the time when you go in practice. By and large, what you're going to be using are the rules dealing with applications and motions. Okay. Now, if you got, it also deals with applications, actions, motions, and orders, discoveries. We'll talk about that a little later. It deals about trial, how you get to trial, because that's different than a motion, and I'll touch about that too. And then it deals with the judgment, and it deals with costs, because I don't know if you realize this, but when you go to court and you lose your case, you can be told to pay for the other person's lawyer. That's not fun. Well, it depends which side you're on. Okay. All right. So my next slide speaks about the difference between an application and a motion. They're two very different things, but they look alike. Okay. The application, that's your original request for the judge to make a decision upon. Okay. I want custody of my child, and I want child support for that. Okay? So you fill out an application. The application is to the court, so the court makes a decision on this, if of course you don't agree with the other person before that's over. That's the application. Okay? In that application, we have I did give you an example of an application. They all look alike, by the way, but I did give you an example of an application in the papers. It's the last page. Okay, it's 1, 2, 3. Okay, it's 3 pages printed on both sides. Okay. So that's the application. That's what we call an originating process. Big word to say that's the first document. That's what starts the whole game. Okay, so you in there you fill in the blanks. You know, your name, the name of the other person. Then there's the first court date. That will be given to you when you go to the court and get a court date, okay? But you don't fill that out, you leave that for the registrar to do that, okay? And then you check the boxes that you need. For instance, the one that says this case includes a claim for support, and then there's instructions. If you want child support, then that has specific things that you need to do, including filling out what's called a financial statement, which is a big piece of paper that has all your numbers, and which usually shows that you should be starving by now, but that's besides the point. I don't know if any of you had to do these before, financial statements. Well, it's pretty interesting because almost every one I make, the expenditures in a month go over the revenue by about $500 to $1,000 for everyone. So it doesn't mean very much. Bottom line is, for child support, it's as easy as saying, okay, how much do you make every year? And then you look at the child tables, the support tables, and tell you how much you have to pay. Okay? I don't find it very useful. It's useful only, the financial support or the financial statements can be very useful when you're talking about division of assets. Okay? When you split, and you're going to have half, it's more or less half and half. And it can also be very interesting when you want to cross-examine someone on that, because sometimes you'll find funny things like, oh yeah, I spend $300 a month on my hair, Oh, 300? I think that's kind of over the top. You can argue that, But when it comes nonetheless to paying child support, it's one of the tables. So, as I was saying, so the application is the first thing. There's the family history, the name of the children, the age of the children, the relationship dates, when did it start, when did it end, are you, etc. Were there any orders before? Because sometimes you come back for at a later time. Once that's decided, you come back at a later time. But this is really the first document that you give to the court. Now, in there, you'll be telling your story as well. Most of the time, it won't be it won't be as personal saying, I did this, she did that. Most of the time, it'll be something like the applicant does this, and the respondent did that. You don't talk to people specifically. But that's the application form. Now, the motion form is an order. When you do a motion, it's to get something temporarily in place until your application is decided upon, okay? Until you get a judgment on the application. In other words, your application might take 2 years before anything is decided upon. Meanwhile, there's things that need to be taken care of. Where are the kids going to stay? Okay, who's going to pay child support? Etc., etc., etc. So the motion is what we call an interlocutory measure, okay, which gives temporary rights to one party or the other, okay, until the judgment on the application. Now, it's very rare that you end up getting a judgment because the motions basically decide a lot of things, and that becomes the status quo, and there's no need to go to the judgment phase. All right.
Can you explain that? You're saying that the motion generally turns into the judgment in effect.
Yeah, but by status quo, basically, okay? Well, here's the best example.
So in other words, it's really important to get the motion.
Right. Absolutely.
And yet that is the thing that has presumably a lot less procedure about it. It's not supposed to be temporary.
Well, I want to talk about that a little later on how to fill the documents and what to do when you get in court, right? But yes, the motion, see, it sets up a status quo. So I'll tell you how it works usually. Someone goes to the courthouse, has got this document ready, he also has a motion and an affidavit that asks pretty well the same thing. Boom, give me a date, gets the date, goes, serves it on the other person. You have a date in 1 week, you show up in court, the judge listens to both parties, okay, makes a decision. Order says custody with David. Okay? Okay, custody is with David. And meanwhile, someone's going to pay child support to you. Fantastic. Okay, so you go home, and then you wait until the next steps of the process happen. But during that time, you're creating a status quo with the child. And once that's created, the judges are very, how can I say, they don't really want to play with that. Okay, the child is used to this, and it's routine, and it's blah, blah, blah. We don't want to play with it. So those first motions are the most important points. Okay. Now, motions are also used for procedural issues. Okay. For instance, say I go to Toronto for this particular case I'm in. Well, comes a time when I think it should be at Kingston, so it's halfway, and we should go to the Kingston courthouse. So I can make a motion in Toronto and say, Well, I think that this should be the case, because right now we're just spending our time, it's not fair, basically. And the judge can say, yes, you're right. So this is a procedural motion, okay? Just to sort of set up the procedure where it should go, okay? But in the case, in most cases, this is what's going to happen. Motions are for interlocutory or in between or temporary orders in order to set something up for until judgment. And in fact, like I said, you won't get to the judgment because the status quo comes in, and then eventually people just kind of fall into that line, and nobody argues over anything else, and life goes on. So you don't get that last judgment. Okay. In fact, a lot of the times on the motion, you'll have settlements. And on the settlements, you settle, you sign, that becomes the order, and that's what runs basically the relationship after that. You have to be careful. That's why you have to be careful of these settlements as well. Okay? You have to make sure that you've got the right things in. There's certain things you can't get around. If you're a child support, it's the tables. Don't even try. There's ways to get around it, but most of us are way beyond. We can talk about that if you have a question after. But it's very difficult to show otherwise. Okay, you usually have to pay. If you make X amounts, you pay the amount that's in the table. Okay. Okay. Yeah, I just spoke about the motion slide or interlocutory process. Let's talk about. Let's talk about the motions themselves. We have the notice of motion, which is form 14. You have the motion form. And I gave you also these forms here. Okay, the notice of motion is something that you will fill out also at the same time as the application, or whenever you have something in between, whenever you want to bring a motion for the judge to decide upon before the judgment of the case. So you'll fill out the notice of motion. You'll notice that at the front of the page you got the names, addresses, and all that kind of stuff. Okay? You won't have a specific time yet as you're filling that out. You have to go to the court registrar to get a time for the motion. Okay? And on the other side of this page, you state what you want. So, for instance, I made a motion, and what I wanted for this parental alienation case, okay, what I wanted was the psychologist to analyze the relationship between dad and the kids, and also having to ensure that dad and kids build up the relationship that's been lost. I lost my motion, okay? I'm supposed to do that, but that's what I wrote down here, okay? I wrote on this, what's the order I want? An order that a psychologist be named on file in order to examine and determine whether there's parental alienation, and if so, to start working on rebuilding the relationship. Okay, that's what I wrote there.
Did you say you're not supposed to do that?
Oh, you can make a motion for anything.
No, but you just said you're not supposed to. Did you say that?
Did I say you're not supposed to? If I said that, I don't.
Okay.
I guess, well, it was denied, is what I said.
Okay.
The motion was denied.
Okay.
And sometimes you can make motions that, well, anyone can make a motion, but if you're losing people's time and stuff, the courts really look down at you at that moment, For instance, passports. Okay? You shouldn't refuse to sign passports. Okay? You shouldn't. There's reasons. This one case I'm telling you about, mom wanted to have the passport signed, but in that particular community, it was a buzz. And the buzz said, yeah, she's leaving, going back to Africa, and chances are she ain't coming back. And the buzz was really loud. So we refused. We ended up in front of the judge, and the judge says, well, you can't do that. But, and we got what we wanted on the other side. It was, you'd have to have consent. You have to let them know when you leave, when you're going to come back. A whole bunch of conditions, travel conditions, okay, on the children. So we basically got what we wanted, but she did get her passport signed. But this is a very specific case. Most of the time, passports If you refuse to sign passports, you're losing the court's time. They're just going to tell you, you're either going to sign it, or I'm going to give an order, and she won't need your signature to have the passports. Okay, that's what the judge will order. So you don't want to waste people's time unless, well, because passports is a right. Okay, you have a right to have a passport unless and you shouldn't, like you especially these. I think you need a passport to go to the United States now. Okay, so that you don't want to stop this mobility kind of thing. Okay, that's why. Okay, but then again, you can limit you can limit the freedom to travel to the extent that you're going to give me the itinerary, the dates, this, that, the numbers of where I can reach the kids when you're over there, whatever. It's not too bad if they're going to Toronto. That's not needed. But like I said, if they're going to, say, Africa or India, or some far off land, going to see family and whatnot, you're never sure if they're going to come back, right?
So does either parent have the right to take the child out of the country without notifying the other person? No, they have to, right?
You have to have a consent.
To leave the country with that.
Yeah. Okay. But, yeah. And in fact, that was another. Yeah.
So how is that enforced?
Well, normally, yeah, the travel arrangements, that's enforced by, usually when you leave the country, you have to have the consent to show it to whoever asks. But it's not really asked often. It's from Canada especially, you only control once you get into the other country, right? When you go to the States, you have to go through customs here in Canada. They check on that. That's done there. They ask for consent. Okay. Also, most of the time, the passport authorities are made aware, or they should be made aware, that it's a separation thing, and the names are put in the computer and looked up whenever the kids get to a customs area. Okay. And yes.
I don't want to derail the conversation too much, but what if there's different last names?
Well, it's the name of the children, the name that's on the passport is the name that.
I'm just wondering how. I mean, it's not really relevant, but if I were to take my kids, my kids have different last names than me. If I were to take them out of the country, am I more likely to get asked for consent for the consent? I don't know if you know that.
Well, let's just say you'll find out when you get that situation. But yeah, no, the name that's on the passport, my client, the children don't have the name of the last name. Okay. And so it doesn't matter. The fact is, if it's in the database and it's been flagged, right? Because like my client, you call the passport office and tell them that there's an issue here and that you're afraid. No problem. We put that in the computer and they flag it. Okay, they can flag it. So I'm told. Okay. Anyways.
Is anybody being prosecuted for failing to catch a child who was being taken out of the country wrongly?
When they were caught, yeah.
Pardon?
When they were caught, yeah.
No, I don't mean the parent.
Oh.
I mean the lack of enforcement, failure, if there was a failure of enforcement of the order, what we're talking about. Did anybody end up being disciplined for that?
Not that I know.
I wouldn't. You don't surprise me.
Or is human, I suppose. Yes, sir.
Just to clarify my mind, so there's usually one application and any number of motions?
Correct.
Is that the case? And so you were talking about the story earlier. Is the story kind of like resides in the application, and the motions kind of don't really have to put any of the story information in there, or is it just it all resides in the application?
Most of the time in family law, what your application says, the motion, especially that first motion, to get that, so that custody is established right off the bat, will have the same story. Okay. Now, the other motions that come up are something different. For instance, we had the case I'm talking about. We never thought we'd have this travel issue come up, so we had to come up with an affidavit that said, no, we won't sign, and this is the reason. So, in the motion, the motion's accompanied with an affidavit, right?
That's part of the story.
The affidavit is your story. Okay? That, in order to speak about these travel and the risk that they were going to leave for good, okay, That story was about that, and not about custody or anything like that. It was this is what the buzz is in that community. We believe them we know they're honest and everything, they would be talking about that. Okay? So that's what that affidavit is. And we're going to talk about affidavits in a minute as well. But anyways, just to get, you want orders made. With motion, you get orders. With applications, you get judgments, okay? And the orders, like I said, a lot of the times they'll end up being the, becoming the status quo. Okay, so motions. You also have affidavits that accompany the motion. Now, sir.
John, I apologize.
Yeah.
Someone I have to pick up was here earlier than what I said. Do you have a business card I can grab for you, please, if you wouldn't mind?
I don't. I left in a hurry. You're not coming back, are you?
No, I'm not going to be able to, unfortunately.
No, unfortunately, I left too quickly, I think. Hang on.
Piece of paper in the check.
Here.
Is there a number I can pick up for this?
Here's the post sergeant things. Leave a message with
Thank you so much.
I won't be able to take on every case, I'm way too busy. Yes, sir. But I can answer some general questions. Okay, so now we're at the affidavit stage. The affidavit, your motion asking for an order for the judge to say, do this, do that. So you have to have a reason behind asking for that, okay? And that's when the reason is, or the justification of the order is done by providing an affidavit. Now, has anyone here written affidavits before? It's a bit, yes, of course, David. Okay, an affidavit is it's a word that before I became a lawyer, I didn't even know what it was. But an affidavit is simply a sworn statement. You're going to swear that everything you said in that paper is true. Okay? That's all an affidavit is. But you can throw any kinds of stories in there. If someone cannot read it, it won't have the effect that you'd like to have. It's got to be written relatively well. Okay? So, in the affidavit, it's a statement of facts. Okay? On such a day, I did this. On such a day, she called me. She left a message to pick up the children. And as told, I went to pick up the children. But when I got there, she wasn't there. And when I tried to find her, I finally found her. She had gone to her mother's. You know, facts. 1, 2, 3. One paragraph at a time. Very clear. Okay? And it's best, an affidavit doesn't need, it can be just as bare as that, okay? And because you swore that it was true, okay? In other words, you're going to come and see me or another lawyer, and they're going to look at, do you swear to me that everything you said in there is true? I do so swear. Very well, sign here. So that's now evidence. Okay, before that sign, it's nothing. It's just a piece of paper with a story on it. But then you say, yes, I do so swear, and it's signed in front of a commissioner votes, it becomes evidence. Now there's a concept called the weight of evidence. Okay? It's probably evidence, but how heavy is it? How much is it going to play in your favor? Well, if it's just your story, it's evidence. It might be true, but it's just your story. So this is the next part of the affidavit, which is super important, is to put attachments to it. Okay? So, I received, for instance, in your affidavit, one of the lines was, I received an email from my ex in which she says she threatened to kill me. Okay? If it stands alone, that's it. But if afterwards you say, attached here to is a copy of that email, or C, attachment A, or B, or C, attached to this affidavit, that is the email that she sent me. So if a judge goes through that, says, okay, yeah, so she threatens, big deals. Oh my God, yeah, this is true. So we're looking at something a lot heavier insofar as the weight of the evidence. So the judge, or whoever's deciding, is going to take this much more seriously. Okay? Sometimes they don't even go to the attachments, because if it says see attachment, Well, if there's an attachment, usually it's because it's true, okay, something's there, right? Okay? And in motions, it is the evidence that the judge is going to decide upon, okay? He's going to look at that, and that's what will determine, or that's what will make him make his decision, along with principles of law, okay? He's not just going to make a decision, boom, he's going to look at the law, say, okay, can I go there or not, whatnot, but definitely the evidence there is going to be considered, okay? Now, motions, there's two types. Okay, you have the hearing, which I'll talk about it in a minute, but you also have what's called basket motions. Sometimes motions are done on a consent basis. Both agree to certain things, but you want that in an order so they can be enforced, or it can be followed, or you can go back. So you put together, you make your order, you prepare an order that's already written up, everybody's agreed to it, everybody initials, everybody says it's okay, and then you go to court and you say, okay, here, this is a motion. We don't need a hearing date. Just put it in the judge's basket. And in that afternoon, when they're working, I'll kind of pick that up. Says, okay, order on consent. Yeah, looks pretty good. All right, sign. That's it. Okay, easy, easy, easy. That's nice. Then you have what's called the motion hearing, and that's when you get at your day in court. And like I said, you can have. We'll talk about the application later, but that's one of the most important things you'll get is your motion. Your motion, okay, the judge will have read the documents the night before, usually, okay, because let me take a step back. You get your document, your motion ready, you go to the registrar, they give you a date, you go and serve that on the other party to tell them, oh, there's a hearing at such a date, you better be there or else. Okay? You go back home, they provide an answer to that, okay, a document that answers that. And then there might be a reply. If you don't agree with certain things in there, you can send a reply, whatever. And then that's put in what's called a continuing record. And then the judge, and then your court date, you're getting closer to it. The night before, or the day before, everything's ready for the judge in front of him, okay? So he walks into his office in the afternoon, usually because the hearings are in the mornings most of the time. He's going to take out the documents and he's going to start reading them. He's going to read your motion document plus the affidavit. He's going to also read the response and read that affidavit there, okay? And then after that, the reply, if there is. And then he's going to hear you. And at that point, he's aware of the facts. He's aware of the contradictions, okay? But now he wants to hear you prove your point, do the proper argumentation, okay? And so arguments are heard, okay, but only on what's filed, okay? So you'll go to court and you'll talk only on what's part of that motion and nothing else. You're not going out of there, okay? You stay there, okay? There's no examination or cross-examination. In other words, you can't, there won't be questions to determine the credibility of the other person. Okay? It's only on the materials file. And basically, you open the motion hearing with an introduction, argumentation, and then you'll close, and then it'll be the other person's turn, and then you might have another shot at it. Okay, but your argumentation is based on the facts, and then that's when you pull out the law, the case law, and whatnot. Okay, and the law is what's going to prove your point. So in other words, in such a case, say you're making a motion for custody. And so it happens that you have evidence that the other parent is a drug addict. Okay? And so there's an issue here because she's got custody, or he or she's got custody of the child. You can't have that. It's dangerous for the child, right? So what you'll do is you'll show up, okay, these are the facts. Okay, she was arrested with drugs, she was high, the kid was sitting right beside her as opposed to being in daycare or whatever, or beside him. You can go both ways, okay? And he was, this is wrong. Okay, right off the bat, you're looking pretty good if all of that is true. But it gets even stronger if you're able to pull out a case that's got similar facts that was decided by a court, preferably a higher court, like a Court of Appeal or Supreme Court of Canada, You see, it was decided in that case that when a parent abandons their kids while they're taking drugs, they're not fit to be a parent. Therefore, custody has to go to the other person. So, in this case, it's the same thing. Therefore, you should decide the same thing. That's how you argue them. They can be 1, 2, or 3 different issues. Okay, they can be more than one issue in a motion. But that's how you would argument that. Okay, you would argue that, I should say.
About like finding those other cases.
Yeah, that's case law. We can, are we going to cover those things? Yeah. Let's move on. We're going to get to that, okay? It won't be long. In fact, what used to be a huge job is now easy peasy, okay? We'll talk about that. Okay, after the motion is made.
John, can I ask you what your timing plan is? Because I'd like people to have a chance to
Right.
discussion at the end, so.
Right. I was hoping to leave room for.
Right.
But
So
I'm gonna take
when are you going to
4.
finish your formal presentation?
Okay.
When are you going to finish your formal presentation and go to Q&A?
Let's move on. Talking about, I don't know. Frankly, I'm behind. I thought it always happens to me, and I never learn. So, judges don't.
Can you get it cut off?
Let's cut off maybe like 22. Is 20 minutes going to be enough for questions? I think so.
Okay.
Okay.
You get about 10% of my story.
What's that?
You might get 10% of my story.
Okay. Yeah, for sure. Okay, so the next slide is motions and orders, or about orders. So after your arguments and stuff, judge makes a decision, judge writes on the paper, okay, photocopies made of that, you go back home, then you write up an order, and then if both people agree that that's what the judge wants to do it, and it's stamped, and once the order is stamped, it becomes the rules by which you need to live. Okay? All right? Okay, I spoke about service of documents. Just so you know, service of documents does not need to be done by somebody else. You can do it yourself. A lot of people think that you have to go through process servers. Not so. It's much better if you get somebody else to do it for you. Okay, because that way, well, you're not putting yourself in harm's way, for instance. Okay? But nothing stops you from serving the documents. So yeah, third party is good. It can be your friend, it can be your next door neighbor, it doesn't matter. Someone who can go and who will have to sign what's called an affidavit of service. Affidavit of service is a document, it's an affidavit, therefore a sworn document, okay, that says, yes, on such a day at such a time, I gave the document to this person, okay, she was served with it, or he was served with it, okay, and end of story. So it's just proof that you did give it to the other party. And if you're going to drop your motion and your affidavits at the courthouse, you need to have that document because they won't believe that it was served on the other person unless you have that. Okay, and that's due process. Okay, can't surprise anybody in this thing. Okay. Okay. It's important also to know that that first document that you're going to serve has to be served in person. But then anything afterwards, it can be served, as long as people agree, you can serve it by email, by snail mail, and you can serve it by fax, okay? You just agree on this, okay? What's a lot easier, these days with email, everything's easy, okay? But that first document's important, has to be given to the person itself. And then, of course, as I said, the affidavits of service back up the fact that they were actually served. Now, if you're served by a document, let's take the notice of motion. There are instructions on that page. It gives you the timelines. This is probably the most important. There's a deadline. Okay, 20 days. If you look at the notice of motion that we looked at a minute ago, it's the affidavit. Okay, application. The instructions on there. This is the application, not the motion. Okay. If you want to oppose any claim in this case, you have only 30 days after this application is served on you to serving file an answer. Gotta watch these things. That stuff. If you miss that deadline, it's an uphill battle after that. Okay? You have to find reasons why you didn't respond in time, whatever. I mean, if you were in a hospital undergoing huge surgery and they put you away for 30 days, then that might work as a good excuse. But anything else, you'll have to justify the fact that you were there, and you don't want to go there. So you want to try to answer that as soon as possible after you've read the document. The fact that's what's being said because you don't believe it. It doesn't make sense to you. Fact is, read it once, relax, do your Zen thing, whatever you need to do. Come back, and then begin your story. That's not the story I know. And that's when you'll start preparing your answer. This is my story. Then you'll start writing it down. Okay, get away from the emotion, and then once that story is written down, especially on computers today, you save it, and then you just print it up when you need it. Okay, and so that's how you deal with when you're served with something. But be mindful of those deadlines. Craft a response within a time allotted. I'm at page 7 there, I spoke about preparing affidavits of service. I also said that if you're the one making the motion, you prepare your documents, you go to the court to get a date for the motion hearing, unless you're doing a basket motion. Most of the time it'll be a hearing, you get a date, and then after that, you serve the document on the other party, right? Then you'll get an answer coming back from them, and then you might have a chance to reply. Oh, let me just a word on the replies. Replies are usually reserved for new things that are brought up in the answer. So, you've got your first affidavit, you drop it in, or your first story, you drop it in, then they respond, and they bring in some new stuff. Well, the replies to address the new stuff that's been brought in. Okay? Sorry. Should have shut it off. All right. Okay. Page 8. So we spoke about applications. We spoke about when you drop it off, you made a claim, I want to meet my children, blah, blah, blah. You've got the motions that come in between. You also have, in applications, then you go to the next steps after that, okay? Which one of them is a discovery. So you have a bunch of affidavits. Before a judge sits there, it's not like criminal court. Criminal court is pretty well, everything is done in court. Okay? In civil matters like this, you've got what's called discoveries, where you've got affidavits, things that were said, whatever, and then you have an opportunity to question the other party with regards to whatever is said, and really put them in the corner if you can. Okay, so clarify this, please. What did you mean by that? Were you really at that date? Because, frankly, what I see here, were you really at that place? Because from what I see here, there's evidence that you were somewhere else. Is that right or wrong? Can you explain that? You sort of play that, and that's all in preparation for the trial. Now, at discovery, sometimes things go so bad that people will just abandon it. Okay, again, you win, let's settle this, I don't want to go any further. It won't happen all the time. In family law, probably, well, like I said, emotions will decide most of the stuff, but if it gets there, it's likely it's going to go to trial anyway. Okay? But you have an opportunity to question whatever they said and try to get at these people's credibility. Okay? Are you truthful with the talk? Okay? After that, those discoveries are usually taped. And then after that, transcribed, and they're very expensive to get. But, you get these transcription, and you can use that at trial. Trial is when you're in front of the judge. That's when you have witnesses. You have the opening statements. This is what we're going to argue. And for this, I'll call witness 1, witness 2, or sometimes you don't need witnesses, depending on how the discoveries went, right? But that's when the case is actually tried. Okay? Trying a case means pushing it every which way to find out the truth. And once you have the truth, then you can make a good decision on that, right? And eventually, it ends up with a judgment. Okay.
So these are discoveries for the application. Like if while that's in the works, it might be 2 years, but new stuff
Yeah.
comes to light and you want to submit that to the body of evidence, I guess, or story. Does that be the idea of what a discovery is?
No, the discovery is to discover if what the other person said, even if it was 2 years ago, if it was true. In family law, like I said, with regards to children, you rarely go there, okay, because the status was established. Now, when you go, most cases where you go through discoveries is on division of family assets, right? So I have a company and they say it's worth $100,000. Okay, but the other side says, no, I know that company's worth $1 million. Okay, well, here's my assessor, is that what you call them? Those people who assess the value of something, valuator. My valuator says it's 100,000. Oh yeah, well my valuator says something else. And so this is where you come with discoveries. You ask questions. You say this, you know, what do you mean by that? Who is your valuator? Oh, he's your best friend. Isn't that nice? You know, this kind of stuff. Stuff you'd probably see like in court, although it's not in front of a trier of facts. Okay, that's what happens. Okay, like I said, in custody, you don't get there very often. Okay, but in alienation, I think that's where we're going to end up because there's so many things in these affidavits that need to be questioned, and you don't do that in front of the judge. You question them before, and then you present to the judge the contradictions that happened that you're discovering. Right?
So for custody, if most things are handled with motions, then what is usually the contents of an application if it doesn't usually get to that?
It's the same thing.
Same thing as the motions.
Yeah, usually when it comes to custody, child support, it's pretty well the same thing. Okay? And like I said, you'll rarely end up in a trial situation. It's my experience anyway, that you rarely end up in a trial situation when you're dealing with custody. Because, with young children especially, because the status quo remains the status quo. So, oh, mom's has had custody for the last 6 months, well, or a year or whatever, we'll just keep going. Okay, we'll keep the same pattern because that's what's good for the child, or so they say. But you know, I could argue that I'm doing the face, but that's what the law is. Okay, but I'm trying to change that in small ways. Yeah.
How hard is it to change? Like, if you're not happy with the way the system is? To argue against.
Well, if you're not happy as being the person who doesn't have custody or doesn't have visitation rights, it's very difficult to change the status quo with family law. In Ontario, anyways. It's, I mean, unless both parents agree.
What about in Quebec, if it's 50-50 default?
It's 50-50 right off the bat, joint custody.
But if something happened and it was not 50-50 and you don't have,
You can make a motion or an application, okay, to change that. In Quebec, I'm not too sure about the success rate. You have something going for you in the fact that you are 50% joint custody with this. And, you know, that's it, that's all. If you have shared parenting to begin with, all the better, you know. Like, shared parenting is 1 week with one parent, 1 week with the other parent, or 2 weeks, or whatever. That's called shared as opposed to joint. Joint is only all about making major decisions jointly with regards to the child's religion, schools, this kind of stuff. That's what joint custody is about. It's not shared. It's not the same thing, right?
I'm just thinking, like, when children are really, really young, they typically end up going with the mom, right?
Yeah.
And so if it's been like that, where it's been, the child's been with the mom since birth or since whatever, and then the father wants to start having more custody,
Yeah.
is that challenging the status quo, or is
That's
that?
it is. Yeah, it is challenging the status quo for sure. If he wants custody, if he wants visitation, that's a different
Or
story.
like if he's had visitation, but he wants
Yeah.
more visitation.
Then, yeah, it's an uphill battle. It's very difficult to get that, yes. Okay. You know, the rumor says that if, I don't know if I should go there, but I'll say it anyway. Rumor says that, you know, mom has to be dead for her not to have custody. Basically, okay? There are cases where mom was a drug addict, not well at all, totally incapable of taking care of the child. Father goes and asks, look, I should have custody of my child. I can't let this happen. There are cases, and I'm going to say it happens all the time, Well, no, well, I'm sorry, we don't believe that you do a better job anyway. And that's it. Okay? It is what it is, okay? Sometimes it's hard, you know? And you know, the thing is, with people in certain situations become very good manipulators. So, for instance, drugs. Those who are on drugs or whatever, and I can say that from a personal standpoint, these people have a tendency to be very good manipulators to get what they want, which means that they can act out, they can say things that they sound and look very truthful. But that's what you have to deal with. I tend to think that things are getting a lot better than it was 20 years ago on that front. I think it's a good thing. The more things are going, the more you recognize that the role of the father in a child's life is very important. We're not there where we say it is so important that it has to happen. We're not there yet, okay? But it's moving gently towards that. And just as a general comment, the law is always behind the reality. Okay, like in other words, it's always playing catch up. Okay, the law takes place to remedy a situation at one point, and it keeps going that way. Okay, and then a new situation comes up, and so well, that's like this situation, so we'll apply that, and it keeps going like this. It's always behind. Okay, and until you get a super judgment that just kind of throws everything over, for good or for bad, right? Okay. Okay. You might want to take for if you're going to go, if you're ever thinking of going to court, or if you're served with documents, there's a website you should note down. It's called Ontario Court Forms. It's on. I've put it on page 9. OntarioCourtForms.on.ca. Okay, and that's where you'll find the forms. Now there's a bunch of them. I think in your package you have a list of all the forms. The important ones I told you about: application, motion, affidavit. Okay, and then sometimes the rules will call for another document. You just kind of go there, you can find it. But by and large, this is all you're going to need. Okay. There's something called the case conference brief. Again, family law, before you show up, you don't get your judgment, you get a case conference brief. And that's all, that comes under the, it's called the case management, okay? So, I said before you're going to go have an application, end up in discoveries, blah, blah, blah. Before you even go there, there's another step, which is called the case conference, where a judge is sitting with you, but the judge is not sitting as a judge. Sitting as someone who's listening to both sides and saying, well, you know, I think you might be wrong here. And I think you should probably, you know, you don't have to say yes. They won't make a decision on anything at that time, okay? They might make an order if they feel that it's necessary. For instance, you haven't paid your child support, garnish. Okay, they might decide to do that at that point. They're entitled to do that. However, most of the times they look at the issues and try to settle it so that the parents don't go up all the way to the end of the application. Okay, they want to try to settle that as soon as possible. It doesn't always work, as it was in the case with this parental alienation thing, but you know that's different. The law is relatively new, you know that, so we'll see where it goes. Okay, and now. Oh yeah, confirmations. So when you do a case conference brief, the form is there. You just fill in the blanks, and what you don't know, you don't fill it in. Okay, just of course you know your children's birth date, so you put that in. Children's names too. You know, everything you know, you put it in. Okay, but what you don't know, you can leave blank. Okay? And if there's an issue, someone at the courthouse will tell you. I find them very cooperative at the courthouse. Okay, so anyway, so you do your case conference brief, and then you send that 3, 4, or 2 days before the case conference, which is not a hearing, but like a hearing, and you have to send what's called a confirmation before that. I think it's 24 hours before that. confirmation is important because that says that, yes, we will be there. You are confirming that you will be there. If you don't send that in, they'll just take you off the roll and you won't get your date. You have to start from zero, try to get it go again, okay? So remember, if you go to that extent, if you go to the case numbers, make sure you fill in that confirmation on time. It's all a question of time, right? 2 days before hearing, 1 day before hearing. Look at the rules, it'll tell you a lot of stuff. So we're going to talk about case law. This comes to your question, where do you find case law? So when I started law school, case law was all in the books. And you had indexes. You had to look in the index. And you classified under case name. Keywords. What else? Date. Issues. So you have to go to the book in the index. You have to find whatever. And people are actually paid to take out these keywords and whatnot and prepare these huge indexes that you go through to find the case that supports your case or the case that will bring down the other side or whatever. These days, it's over. You go on the internet, you go click, flip, you find it. As long as you're good with handling keywords, you should be able to find the cases you need. The one place you can go, it's in the document, it's called canlii.org, C-A-N-L-I-I, which stands for Canadian Legal Institute, something. Anyway, I forget. But you go to canlii.org, and it's very easy. You click here, click there. You'll find your way. You've got a keyword search. You also have a case search if you know the name of the case that you're looking for. And it's a lot easier. Now, you also have all the laws in there. So, if you go to Family Law Act Ontario, and say you're talking about the section that talks about custody, right? So, in Canley, what's really nice, because there were other books for this before, what's really nice is that you click on the section number, and it'll ask you, do you want me to give you all the cases that have spoken about this? Yes, so you click on it, and boom, you've got a whole bunch of cases. Okay, and you can look through them. Sometimes what's really nice, sometimes you get like 5 cases. And that's easy to read through and find out, Sometimes you get thousands of cases, so you have to sort of sort through them. But it's a lot easier than looking through books. So go have a look at Canley. It's a wonderful site. It's got the laws of every province. It's got the federal laws. It also has case law that's been decided on that. And in Family Law Act, Children's Law Reform Act, and you click on whatever section and it's wonderful. It's made my life a lot easier, put it that way, as a lawyer. Okay, does that answer your question? Yeah? Okay. There are other sites, by the way, that have case law, but that's sufficient for these purposes. I spoke about arguing the case. Preparation for arguing can be difficult. It requires concentration. The internal dialogue rolls and rolls and rolls. But the main thing is to stay focused. Focused when you prepare and focused when you argue. I like to do it this way. The day before, or 2 days before, I start with an outline of where I'm going to go, based on the stuff that I wrote, right? And you focus on that. So, in front of the judge, you'll say, today I'm going to argue this. I'm going to say this, this, this. Okay? So I'm going to start with, for instance, I'm going to talk about the facts. Then after that, I'll pull out some case law that supports what I'm saying. Okay? And then, conclusion, where you reiterate the fact, this is what I'm asking, and in fact, you just repeat very briefly what you just said. In fact, this is what I'm asking, and in fact, all the case law I gave you supports that, and the reasons it should be that way is because it's the best thing for the kid. You finish like that. It's very, very brief, okay? It's the middle. And a lot of the times when you're in front of the judge, what might occur, and this is, things are either very good or very bad, a dialogue starts happening between the judge and you, and you're no longer with your notes. Okay, so, if you know your stuff, your case, relatively well, or you should know your kids well, and you can control emotions and whatnot when you record, you can have a really super dialogue or a really terrible one, because sometimes they ask questions and just want to go under the table because you don't know the answer, you don't know what to say, okay? But that dialogue, and that, I find that those are the cases where things have worked super well for me. And the judge is trying to know something, trying to be able to, wants to sit on something and say, yeah, you're right. And he wants you to tell him that, because the judge doesn't necessarily know everything, and you're the one, you're the person helping that judge to come to that decision. So he's not chastising you, he's not doing anything other than trying to get that information so he can make a decision. Okay? So if you get to that point, the judge asks questions and you start dialoguing, it's usually a good thing. I don't know if it's not a good thing, trust me. Okay. So we covered here a number of things. We spoke about the law. We spoke about legislation, what legislation applies. I don't know if anyone we won't go through that, the Divorce Act, the Child, the Family Law, etc. We looked at, well, case law in support of that. That was near the end. We also looked at forms. We looked at the process. I hope that I gave you a good idea of what the process is, because that's where you'll stumble most of the time. Okay, you know what your story is. You just have to know how to present it in the forms and in the way that the courts want you to present it, right? So that's why I went through that exercise. And perhaps we'll have another workshop where we'll just work on affidavits. I think that'd be cool. And if we just had a workshop, we'll write affidavits. There won't be a lecture there. I think we could do that. Keep that in mind. Okay, that's the next one. Okay. Great. Yeah, so now we can go on to the questions, I guess. If there's any questions.
Right, I'm going through a very complex parental alienation.
Okay.
I went through it in the beginning of 2010, January. My ex decided to sleep with the guy that was living in my house and then orchestrated an assault against him. And he had threatened me when I hit him and started me with assault, kept me from my daughter for 9.5 months. I got a court order letting my daughter every weekend. We would go to motorcycle events. My ex wanted to come and I brought her because she kept asking in front of my daughter, and I try to keep, so that I can be the better man. Like, okay, we can get along together and do something with your mom and everything. She had to sleep with one of the guys there. So now she wants to go to another bike event. I won't take her. So her and her son attacked me as I'm leaving with my daughter. My daughter defied her and didn't stay. She goes, well, Lily's not going. I'm going. And Lily left with me. So the son jumps in the back of my truck, picks up the chainsaws, and smashing, trying to break my window. She reaches in, trying to grab me, and I'm trying to leave with the truck. She ends up getting run over. So now she will not let my daughter come and see me. My daughter is brainwashing her.
How long has it been?
It's been 5 months now.
All right, get to it. Now, you got it in your papers. I have a right to see my daughter. There's a court order, and if she doesn't, well, she'll definitely.
I've already got a motion to go to court on the 23rd of February.
Right. Okay, so your paperwork's filed.
Yeah, I have a lawyer.
Oh, you have a lawyer doing that. Okay.
Yeah, I had to quit work to get legal aid.
It's yeah. Oh. Unfortunately.
She's got mental issues. She's under Canadian mental
Yeah.
health.
Well, and in all fairness, the other side is saying the same thing about you. Because I get this all the time, right?
I don't have the history she has with CAS, where she lost her kid for drug problems and didn't have her kid for a year until I got together with her.
Right. Okay.
Helped her get off.
But it's an uphill battle. Is the way it is. Okay, the fathers have the shorter end of the stick. You got to, but the main thing is not to let go. You keep going. I want to see my daughter.
Every week I send somebody to try to pick her up because I have no contact work because now I'm getting charged for criminal negligence because she got run over because she was attacked.
Yeah. Which it's always best if you call the cops in those instances.
Oh, I have it all on tape recording. That's the difference.
All right.
So,
Okay.
Because they would have charged me with
So
a weapon with beat the vehicle.
What's your question exactly then? talking about your kids, but the question exactly?
Yeah, I'm just saying, like, you're talking about parental alienation.
Yeah.
Apparently the courts don't recognize parental alienation.
Well, okay, that's a good, parental alienation, in a way you're right, okay? But it's up to you, me in my case, right? To bring it forth and make it apparent to the courts that it actually exists. And you know, again, you're trying to convince someone who's in charge of applying the law. So, yes, there's a bunch of them that says there's no such thing as parental alienation. Now, in order to, you've got a lawyer on this, but in order to prove that it actually exists, you get, I spoke about affidavits, right? You get papers, the internet now, you can find anything you want, okay? You get very serious research done on that, in the United States especially. God, it's amazing what they put on that. Dr. Baker is one of
I'm on the
the
parental
top
alienation,
doctor. So you print out these pages, and the affidavit. I'll tell you, in one affidavit, what I did, and this is, you're not supposed to do this in affidavits, it's supposed to be factual. We're talking about motions here, and you know, you've got something, I've got a goal in mind, right? So what I did is I took out that document. It's a big book. You just take like the summary of it, right? And you take out the indicators of alienation, because she's a very good researcher. So, well, this is how you can recognize that there's an alienation or not. You've got 1, 2, 3. There's about 13 things. Okay, if some of these are present or all of them, chances are you're looking at alienation. And then, so I said, this is what she said. And the next page was, well, this is what's happening in my case. Boom. So under that heading, that test, this is what happened. Then that test. And so when you present that to the judge, who's by no means a psychologist, right? He gets, and I'm talking about this motion and affidavit, he gets the authority, and Dr. Baker's an authority on parental alienation. She knows about it. She says that when this happens, and in my case, it does happen. Therefore, you don't really have a choice but to conclude that it exists, right? So, but they'll decide as they want, trust me, okay? That's not the point. The point is that you've made your case as best as you can, okay? In my case, it had partial success.
right now, my motion is contempt on letting my daughter come. Am I allowed to put the tape recording up during the motion or something?
No, not in the courts. No, but they do tape that. You can order recordings of.
No, I don't want tape in the court. I have the tape recording of what happened where she was trying to stop my daughter from going with me. Her story is now that she was trying to stop me from bringing my daughter to a
Well, I think you should speak to your lawyer about that. I mean, you know, your lawyer can actually, okay, but tell him, you know, have a recording.
Yeah, I already gave the recording to my lawyer.
Okay, well, so you're doing the right thing. You had a question?
I was wondering if you had any case law examples that you could hang on to, or if there's a resource somewhere where you know that would be particularly applicable to fathers' rights or situations where fathers have gained
No.
more of a, no?
I don't have, no, I don't, like I said, I go on Canly and I type keywords and it just throws it back at me. So, yeah, there's certainly someone's thought of keeping a corpus of all these case law that deals with fathers' rights. I think there's more of them in Quebec and probably even more in the United States. Although, compared to the other, the mother's rights to the children, there's probably 90% of this moments, right, in case law. But there's probably some, and like in case law, the higher the part, the better the authority, right? So if it's a court of appeal case, then you're looking at, so there's hardly any of that.
Yeah,
And Supreme Court of Canada, God, with the judges that were there in the last 20 years, on family law, it was like, you know, it's stupid. I mean, never mind.
It would be worthwhile though, like, to have that somewhere, like everything. That
It would be.
You do a search, or someone do
Yeah.
a search, and have that pull all those records together, so that somebody who's looking at filling out some documents. I mean, you have to do the work yourself, but it would be neat if you could just go somewhere, click, and say this
Yeah.
applies.
Agreed, but at the same time, like I said, I mean, if you were 30 years ago and everything was paper-based, I think that'd be great. It's very good to have, it's a very good tool, but frankly, searching these databases, case law, it's so easy that,
Yeah.
you know, I mean, you're right, it would be a great tool. In fact, it might be a great tool for cafe to hang on.
That's what I'm thinking.
Yeah, yeah. Things in there and everything you have to look at, but it would be, a lot of them are public anyway, right? Everything that's on Canada is public, so it's not an issue. But yeah, that would most definitely be a nice reference to have. Jamie?
I was thinking, for all the cases out there, it's clearly designated who's the mother and who's the father, or you know whether they're a same-sex couple, and all those details are embedded in the case law themselves. Would it be possible if you were, you know, to take? I mean, if it's a crazy idea that if you saw a case law where a mother was able to do something, and you said, well, she's an individual, not you know, like just remove gender from the whole
Right.
thing, and say, well, she was able to get this. Can I apply this to myself as a man? You know, sort of
Yeah.
remove gender from the case law itself. Is it even in the realm of possibility to do?
It's in the realm of the possibility. Now, to what extent is it going to work? No, because you're showing up there as a gendered person, no matter how you look at it.
Well, you can get a doctor now to change her gender. Actually, Lauren Southern did a thing. She did it. It took 2 hours.
Yeah,
So you know, I could be a woman tomorrow if I wanted to. That's no problem.
agreed.
But,
Agreed.
you know, legally.
But let's come back to Jordan Peterson. You are what you look like.
Yeah.
You look like a man.
Gender expression. Yeah.
You are. So, assuming that you can make yourself look like a woman, show up in court, and have everyone believe that you're a woman or a mother as opposed to a father, it might increase your odds. And yeah, I mean, this is something that needs to be tried at this point, I suppose. I haven't met anyone who was willing to go there yet. but you know, who knows? But
Would that be one of those like precedent-setting big rulings where it's like all of a sudden gender doesn't matter in case law?
well, if you were to do that and gender doesn't matter in case law, if you were successful, yes. I doubt that you will be, at least not in 2017. Okay, perhaps in 5, 10 years, depending on where society goes. It's a very good idea, but the concept is pretty interesting. It is
If
really
it was
interesting.
authentic.
Hmm?
If it was authentic.
Well, no, I mean all the stuff that I was saying about
Lauren saw them, you know, she's a man. No? Anyway, she's playing the game.
I know.
Okay.
Where does the gender bias show up in the family court system? Where does it actually operate?
It operates with case law. It operates with judges. I'll give you my personal explanation on that. Remember I said that the law is always behind, right? It's always playing catch up. Okay. Now there's reasons for that. When someone's named to the bench, they're a judge because they know the law, because they've seen cases before. But they also have a set of values. And those values are deeply ingrained. So 20 years ago, you would end up in front of a judge who was, I don't know, 60 years old, who was happily married all his life. Wife stayed at home, took care of the kids. Never had to worry about very much, had everything. The whole concept of separation in custody, going to dad, no, dad, you're supposed to go out and work. That's what's going in his mind, that's his values. And so that's what was playing, and that's why for the longest time, case law, well, partly that, partly the fact that you had these academics who came up with these really nice theories like the tender years doctrine or other things like that, that were believed by the judiciary because it made sense to them, right? That it fit exactly with their values. Okay? Now, that created this case law, kept going, and of course there's the whole idea of feminists, for instance, those who were at the Supreme Court of Canada. I'm thinking of the Moji case, I'm thinking of the Daigle case, and the Daigle case was I think his name was Tremblay. He didn't want her to get an abortion. He wanted to have a kid. And so they said, that one ended up by saying, well, yeah, we understand you, but, it's her body, so it definitely is, so you don't have any rights. And you, so that was, so you have a, you know, it just kind of follows like that, but it's behind. So that's why it's going to take a long time to come. Now, the judges that are named to the bench today, if I'm going to come back to what I was saying, are very likely these people who have not necessarily had a happy marriage, who were probably divorced twice, probably lost their children, probably lost half of everything they had due to the division of family assets. They're going to have a much more critical eye because their values now, even though they had values that were very traditional before, their values now are gone topsy-turvy after you go through that experience. So they become a judge. They're much more in tune to listen to what's going on in other people's lives. You know, their value system is no longer set. So they're much more open to changing things. I don't know if that answers your question. All right, because it's a catch-up game, basically. So,
I have a question. I don't have custody, and I have flexible visitation access,
right.
and I was living further away from my child, and now I'm closer, and I would just like to go about defining flexible access more. In the beginning it was pertinent, but now the situation has changed, so my ex isn't that receptive
right.
to changing, so what would you suggest? I've drafted kind of documents and things.
This is Ontario, I suppose? She's in Quebec?
She's in Quebec. Our separation agreement was signed in Ontario.
Yeah, the child's in Quebec, so you have to try to work it out before anything else. And if she's not open to that, drop a motion, drop an application or motion under the Quebec rules, right?
Okay.
Go to court and see what happens. I mean, I doubt that you're a danger to the child. I doubt that you don't have a relationship with her already, if not by telephone or something like that. So just force it. I mean, this is how we're going to make things happen. This is how the law's going to change. Now, just so you know, when I speak to judges, when I spoke to judges, certain meetings and whatnot that I went to, they hear fathers, they hear the plea of the fathers. But damn it, nobody comes to court. We can't rule on something when nothing comes to court, because a lot of men, or fathers I should say, have a tendency to just let it go. Geez, I've had enough. This is, and you know, it fits within the archetypal male, right? I've got other things to do, more important, okay? I'm moving on, okay? And that happens, so in other words, there's not that many cases of men going to court. Therefore, there's less decisions on men and fathers. So if you want to counter that, you go to court with that. When there's no cooperation, get a decision. It might be good, it might be bad for you, but one way or the other, it's a case, and if it's good for you, it becomes case law for somebody else.
Right, I guess I think it's not so much just about better things to go and move on, but it's just that the success rates are low, so when you take it to the court and it's not a good decision, what is that? The rest of the relationship?
It's always a chance you have to take, okay? And if you don't take it, well, the less people, the less fathers take that chance, the less we have things law that works in the favor of the fathers. So, yeah, so you might be one of the martyrs that need to go through. Hopefully you won't be, but you know, there will be martyrs through there, and gently things might change. But it's not going to change that quickly if you don't take action. Okay? Oh.
What would be the risk if you went to court? Like, there's financial risk.
Yeah, good point. Excellent point. There is a financial risk going to court, because if you lose, you might have to pay the other person's lawyer's fees. Okay? It's called costs. If your demand was reasonable, costs are not automatic. If the demand was reasonable, there's no real reason to award costs. But the rule is, if you lose, you have to pay. The judges, though, have a lot of discretion to say yes or no to the costs. Okay, this is what happened in this case. I didn't get my psychologist like I wanted to, but the judge said, it's okay, don't worry about the costs. It's a very new issue that was going to analyze, to look at. And it's, so there's a lot of discretion here. And in the case like where you want to see your child, you want to come back, and especially if you show to the judge that it's in the best interest of the child to have a relationship with the father. Chances are you're either going to get it. If you don't, the demand is reasonable. They just might say no costs. That risk is there. It's true. It's true. Yes.
I think there's also the risk of like, if you challenge the mother, that the mother might all of a sudden be like, I didn't like that you did that, and then it's a retaliation on you privately, not influence. But I was just thinking, this is why I asked that example earlier, is if the child, like the courts automatically say that when the child is born, I mean, especially if you're breastfeeding, that the child is better off with the mother for logistic reasons, but as well as, the way the law is set up. But then at what point can you, as a father, ask for more? I mean, we talk a lot about stuff like drug abuse or whatever. What if you're not trying to say that the mother is a bad mother, but you just want to eke into having, a gradual and more presence in their life? Like, I don't know what your flexibility of, what did you call it?
Flexible visitation.
Is it like, does that mean that you can get more custody later?
Well, the custody is out of that. It's just like flexibility and visitation, but just the way it's defined, it could be absolutely nothing. It could be I show up at the door and the door's locked. That's still flexible custody, or it could be flexible as in like Monday or Tuesday, and that's completely at the discretion of my ex at this point. So it's like that's where pissing off the other party. It's not about the legal repercussions, but it's just sort of more social ones.
So how do you?
I didn't pick up on the flexible thing. I think it's better to get set. Flexible is when two people get along.
Yeah.
If that doesn't happen,
well, I mean, but it
set
is
very, every Wednesday evening, and then every weekend or second weekend or whatever. That way you have it. And if she doesn't comply, or if the parent doesn't comply with the order, well, you can go to the police.
It's a contempt then.
You can go to the police, and make a report. They won't do anything, but at least there's a police report there. And when there's many of them, then you, what do you call it, contempt of court. Then you make a motion for contempt. Okay, and might not win that one, but after 5, they might sort of start listening to you. Okay. But and then of course, the fact is, sometimes it'll piss off some people. If you drop court papers, most people are very averse to that, right? Not everyone. So that's why it's best to try to discuss this. And if it doesn't work, you don't threaten to go to court. You promise them. It's as simple as that. And so they've been forewarned. So when you drop a paper, it's not as much of a surprise. Okay. It does, unfortunately, this process, what do you call it, confrontational process, it does have its drawbacks. But it's in human nature, sometimes there's just one way to get things done.
I don't know if you can comment on this, but do you know of any resources for people for mediation or things that could come before the courts that you're aware of? I just don't know.
Mediation, I think, is a very good idea, but mediation has to be properly run. I have my views. There's different types of mediation to begin with. Okay, there's mediation based on interest-based. Okay, what are your interests? I want to have a healthy relationship with my child. That's my interest. What's the other person's interest? I want you to have a very good relationship with your child. Well, then we can come to a settlement tomorrow, or now, for that matter, right? That's interest-based. That's where you're at on that. Now, they don't all work like that. Sometimes the mediation is shuttle, what they call shuttle. And what it is one person goes to one part and says, what is it that you want? I want that. Okay, they go back, this is what that person wants. What do you say to that? And so it becomes like a negotiation thing. It really doesn't lead to win-win situations. But mediations can bring you to a win-win situation. And of course, you have to keep talking about the best interest of the child all the time. It's best for the child that I have a relationship with.
I actually have an answer to that. Because in Quebec, every person that goes through separation is provided with a free mediator, and it's a lawyer, a trained lawyer, and you get 1 or 2 sessions per year. And you can correct me if I'm wrong, I think it's regardless of your income.
I don't know, I'm not, you know.
I had that myself in my separation. We didn't have to pay anything, and they don't represent one party or the other. They're just there to tell you, hang on, you can't ask that, or if you're asking that, do you know that your rights are? So that is the free thing.
But only during the actual process.
No, it's every year. Every year you get 1 or 2 sessions every year.
Well, you might want to look into that.
Yeah.
Yeah.
That's great. I forgot about that, yeah. I don't know the workings of it.
Well, they do it because at least 1 a year, because every time tax time comes around, you have to recalculate your custody or your child support. So.
Okay. And must save on the frequency of people going to court and all that kind of stuff. So.
Yeah.
But that includes also visitation and all that kind of
Yeah,
stuff.
you can talk about this.
Yeah. Okay. Any other question? Okay.
Yeah, they were saying about the mediation, you got a mediator going in, and they're saying, okay, who's gonna have the kid, the father or the mother? The judge says, okay, the mother goes first, the mother goes, well, I carried that kid for 9 months, and went through the pain of labor and everything. So she figures she should have the kid. The judge says to the father, well, what, what's your story? He goes,
I carried both of them for the whole 9 months.
no, I go to the pop machine, I put a quarter in, and the pop comes out, who owns that pop?
Okay, that's one way of looking at it. All right. Okay, well, I guess that's it. I hope it was informative to you, and hopefully we'll see you around. Maybe at the affidavit workshop, we should probably look at it. Thanks.
That wraps up this session of Fathers Win. If you're a dad fighting for your rights, remember, knowledge is power. The more you understand the legal system, the better prepared you'll be to protect your relationship with your children. Remember, this is from our brothers in Canada. What does that mean? That means for all of you in the United States, all of you listening in UK, I know some of you are listening in Jamaica. This isn't going to be apples to apples. But this is going to lay a lot of good groundwork for Western Family Court. So if you are starting from square one or you just need a refresher, this is a great video to do that. I am not saying that this is your legal counsel. I am not saying this is going to help you indefinitely. This is just a good way to lay the groundwork for the understanding of how family court works. Remember, guys, the Bible says, my people perish for lack of knowledge. Get gamed up, go to your legal law library, ask questions, and if you can afford it, find some legal counsel. I am not a lawyer. These are just my observations, and I wish you all so much success in family court. God bless you guys. See you on the next one. Peace.
Stomping around in suburban boots, sliding the pterodactyl inside a red tire, sliding some red sandals.
One dad at a time, fathers win. We're in our prime. Pleasure, truth ain't no crime.